Hello, everyone, and I am Cathy Bates with Practical Solutions, and we are continuing our series on planning for when the time comes. So we've talked about getting your physical house in order and making sure you're not leaving a mess for your kids. We've also talked about getting your finances in order and having a notebook with everything you need for your children or loved ones when you pass. And today we have Esther Wang talking about the importance of trust. And Esther started her practice in 1991. She's an elder law attorney. I met her about 16 years ago. And even though her practice has grown so much over the years, she still gives each of her clients that personal attention they need. Everyone that I refer to her just goes on and on about how she takes care of so many things. So whether she's doing estate planning, aid and attendance benefits for veterans, or doing Medi-Cal and Medicaid, she just gives a lot, brings a lot to it and knows what she's doing, and then is very personable. So we're looking forward to having her today. So Esther, I would like to start by asking, what's the difference between a will and a trust?
Essentially, I want to thank you, Cathy, for your kind introduction. And in the estate planning realm, people usually talk about a will versus the trust, and what is the difference between a will and a trust. Typically, a will is an instrument that describes the wish of the person who is planning his or her inheritance and giving to their children, for example. So a will is going to end up going through probate. So if you put your house and your assets and you describe them in your will, know that your will will end up going through probate. Probate is something that most people wish to avoid, so they will turn to a trust instead. In a trust document, a trust will designate the trustor, which is usually the person who has the asset, and the trustee, which is usually also the person with the asset. But we can designate successor trustee. In my case, I am the trustor of my trust along with my husband. It's a married joint trust. We are both the trustees, and we designate our children as successor trustees, meaning that in the event we're unable to manage our own affairs due to our own death or incapacities, then they will be able to handle it for us. So a trust document allows someone during your own lifetime to handle your affairs for you. And you also designate beneficiaries. Now, in a trust, if we put assets into the name of the trust, the asset will not have to go through probate. It's going to be able to give to your children more privately without the publicity or the cost or the delay caused by probate in this case. So in the legal realm, attorneys will prefer trust over the will. However, if you are a younger person or if you have young children under the age of 18, please know that the will is the only document that can designate guardians of minor children. So you may want both if you have young children or any minor that is under your guardianship. So that is a typical difference between a will and a trust. Another thing to be mindful of is that if you happen to have beneficiaries or children with special needs, such as someone on SSI disability benefit or someone who's on Medi-Cal benefit and on government benefit, you want to make sure that if you wish to leave asset to that individual, that person's inheritance has to be in a special needs trust, which essentially is a sub-trust created in a revocable living trust. So if I have a special needs child, I would create a trust and I would say, I want my asset to be divided among my children equally, but for this one child's inheritance, I don't want her to lose her special needs benefit through the SSI, which is health insurance and cash benefit. And I will put her share into a special needs trust. Now, know that in a will, it is not as easily created. It can be created through the probate court, but it has to be created correctly so that the child doesn't lose his or her Social Security SSI benefit. So if you have a special needs child, I would strongly encourage that you want to establish a trust instead of a will. It is the weight of legal authority that attorneys will make that recommendation. Also, if you happen to have children who have poor credit, likely to have bankruptcy down the road, or you have children that you're not too sure about their marital situation, and you think that maybe that child will end up having a divorce down the road. In a trust, we can leave inheritance to our children, and we can create a sub-trust for that child, which has divorce protection and creditor protection. So which means that even in the event the child end up having a divorce, or the child end up having to file for bankruptcy, the child's inheritance will not be subject to a family court's jurisdiction or a bankruptcy court's jurisdiction, even though the child's personal asset will be subject to that, but not his or her inheritance. And those are the basic difference of a will and a trust.
When is it necessary to have a trust, and when is it okay not to have a trust? I know I've heard before, if you have 500,000 in assets, you need a trust in the state of California.
Okay. Oh, that's an excellent question. Generally speaking, we recommend that everyone with real estate, like a home, we highly recommend that we set up a trust for that home, okay? And if you have no home, but you, let's say you have just moved into a smaller assisted living or independent living facility, you had just sold your home, and you have put all your proceeds into bank accounts and investment accounts. Now, assuming you don't have special needs children, and assuming you don't have children who require divorce and creditor protection, then in that particular case, if you don't own a home, it will be okay to just do a pay on death designation on your bank accounts and investment accounts, and you will not need a trust. Specific situations should be discussed with your estate planning or elder law attorney just to make sure that is really the case. But if you have a real estate interest, it is always recommended to have a trust instead of not having a trust. Yeah.
Yeah, that's nice. I didn't really fully understand that. Okay, what's the difference between a revocable living trust and an irrevocable living trust, and when should they be established?
Now, a revocable trust refers to a trust that can be changed at any time, that you can revoke it. And it is usually the ideal one to hold your regular primary residence and your assets. Now, an irrevocable trust is typically established at the time that we want to do asset protection. If you are afraid that you may have creditors down the road for your own asset, not just for your children, or if you wish to qualify for government benefits and you have excess resources such as rental properties and too much liquid asset, we may recommend to set up an irrevocable trust so you can still qualify for government benefit.
Yes, I know you've done that for a lot of my clients to get them aid and attendance benefits or Medi-Cal. Yeah, I appreciate that because it does help them, because sometimes you're in a situation where you have a certain amount of money, which the government says you have too much to get those benefits, but really and truly, you don't have enough for the care that you need. And so you're able to shift things around and create that trust and get them those benefits. That's great. One thing we did when we did our trust was an advanced care directive. How does that fit into the estate plan?
Okay, the advanced healthcare directive is not a trust at all, but it is a document that usually comes as an ancillary document to the trust. Advanced healthcare directive essentially designates someone to make decision for you, healthcare decision in the event you are unable to do so, and also indicates your wishes for the end of life. For example, if you wish to have a heroic effort to receive resuscitation, or if you wish to have pain relief, do you wish to have your organs donated upon your death? And those are the wishes that will be indicated on the Advanced Healthcare Directive. Though it's not a trust document, it's very important to designate a surrogate decision maker to make decision for you when you are unable to do so yourself.
Right. I know that, the whole series we've been doing is trying not to leave a burden for our family. And to me, that's one of the most important parts, because I don't want my kids to be struggling with, should we take her off the ventilator? Should we not? I want those things to be laid out for them so that they know what our wishes were and they're not feeling this guilt over it. So I think that's so important. So Esther, tell us how to find you, and what, I know you do consultations. Tell us all about that, how they can get help from you.
We are in Redlands, California, and our phone number is 909-888-7100. And you can find us online too if you wish to read up our website, and that is California-elder, ELDER-law.com. And give us a call, and we have a complimentary consultation. For the first consultation, that we will talk about your estate plan, how to set you up so that you can also avoid probate and to get government benefit at the same time when the need arises. So either call us or find us online.
Yeah, that's great. And if you do not have a trust, please contact Esther. She's fabulous, and it'll help you. The whole thing we've been talking about in this series is, putting things in order so that our family doesn't have to struggle later, but also doing all these things helps you live life to the fullest and not be, worried about the future. You've got your plan in place. So Esther, I thank you so much for coming on today. And we will hopefully get you back on again to talk about aid and attendance.
Okay. Thank you so much, Cathy, for this opportunity.
Okay.
And, goodbye, everyone, and have a good day.